Guys, how are you? Today I will be dealing with section 3 of the Limitation Act, which is given in part 2. In the previous video I was dealing with the definitional part of the Limitation Act, but now only important section 1. One section I will be dealing, and that section is section 3, which talks about the bar of limitation. As you know, that limitation means the period of limitation provided or prescribed for various categories of the application or appeals or suit, right? In that case, what will happen when an application or an appeal or any suit is filed beyond the time limitation period prescribed or provided in the schedule of the Limitation Act? So section 3 talks about that. Section 3 strictly says two things which is very important for your judicial examination purpose. First, if any application or suit is filed beyond the limitation period, the case will be dismissed. It is written straightforward that case will be dismissed if it is filed beyond the limitation period, right? Second point, it is also stated therein that even though the defendant has not taken it as a plea, if defendant has not raised any objection in this regard, whether the application is beyond the time limitation or beyond the limitation period, it does not matter. The court will dismiss it immediately, suo moto. Okay, suo moto, right? However, in this section itself, it has been stated that the section 3 is talking about the bar of limitation if filed beyond the limitation period. However, there are some exceptions, and that exception has been given from section 4 to 24. Correct? So from section 4 to 24 is the provisions wherein delayed application can also be taken into account or taken into consideration, or can be filed and court can admit it or allow to admit it, right? But I am not dealing about that. How only I am dealing this what section 3 says. So first clause says the dismissal aspect of the filing appeal or any appeal or suit or an application if filed beyond the limitation period, right? Now clause 2 what says? Clause 2 talks about the institution of suit. It is considered that when the suit will be considered as instituted, means कब ये suit file माना जाएगा, right? In this regard, there are three positions wherein it has been provided. First position, in general and ordinary cases, if any application or suit is filed before the proper authority, then it will be considered, or it will be construed as the suit has been filed. Okay. Second point, when in the case of a pauper category, means any person is thinking that that person is not able to hire any professional advocate or something like that, and he wanted to consider himself as a pauper category, then in that case he will be filing an appeal before the proper authority of the court. In that case, the application filed by that person for consideration in pauper category will be considered at the date of the suit filing. Okay, right? Second point. Third point, in case of the winding up, if any company is going to be wind up by the provision of the act or provision of the law system or law, and generally it is done by the NCLT order, in that case, or you will go through the act of IBC, then you will find that the provision with regard to that IBC and Company Act. Correct? So if any company is in binding up situation and liquidator has been appointed, in that case, if any person is making an application for claim against the company, then the date of the filing such claim before the liquidator will be considered as the date of the suit filing. Correct? So this is these three positions. Now in section 2 itself, clause B, means second part, is dealing with two types of suit. First type is set up suit and second type is counter claim suit. Now section 2 says that both suit will be considered as separate suit. So for your judicial examination purpose, you have to remember that this is not a general suit or this is not a combined suit. Both are considered as a separate suit. Suppose in a particular case, an original suit has been filed against certain person, and that person is also filing a setup suit or also pleading for setup of the claim, then the date of the filing suit by the counterparty in the form of set of suit will be considered as the date of the original suit filing. Correct? It means that when the original suit is filed, that date will be considered as the date of the set of suit. Correct? In second situation, when the counter claim is filed, in that case, date of filing suit will be the date of filing counter claim. Date of filing suit will be considered as the date of counter claim. Right? Now, third part of section 2 is when the notice of motion is filed or an application for notice of motion is filed before the High Court. In that case, what will be the date of suit filing? In that case, it is stated that when the application of notice of motion is filed before the proper authority of the court, that date will be considered as the suit filing date. Clear? So section 3 talks about the impact of the application filed beyond the limitation period. Section 3 talks about the status of the date for filing suit in case of different situations. For example, in ordinary case, in pauper categories, or in case of winding up companies, or in case of a notice of motion before the High Court. Correct? And it is also stated that section 3 says that set of suit as well as counter claim suit both are separate. It should be treated as a separate suit for legal purpose. Okay, guys. So stay tuned to this channel, and I will be dealing each and every important topic for your judicial examination, and that should be very precise. Okay, so that your time should not be wasted and you should get the clarity of the concept of the provisions given in a particular act. Okay, so keep watching.